Welcome to Chapter 11 on Agreement. A valid offer creates a power in the offeree to create a contract by agreeing to its terms. The law determines whether a person intended to make an offer by looking objectively at all the facts and circumstances in which it is made. The law of offer and acceptance is premised on the common law concept of meeting of the minds, in which an offeree understands and accepts an offer on the same terms as the offerer. Vagueness or ambiguity in an offer or acceptance guarantees problems and may lead to litigation. The executive or consumer who articulates to herself precisely what she wants and then bargains clearly for it is likely to spend more time doing business and less time in court. Henry David Thoreau said that it takes two to speak the truth, one to speak and one to hear. Parties can form a contract only if they've had a meeting of the minds. This means that they must understand each other and intend to reach an agreement. A judge will then make an objective assessment of any disagreements about whether a contract was made, whether or not a reasonable person would conclude that there was an agreement based on the parties' conduct. An offer is an act or statement that proposes definite terms and permits the other party to create a contract by accepting those terms. There are many problems with intent. For example, an invitation to bargain is not an offer. A price quote is generally not an offer. An advertisement is not an offer. A letter of intent may or may not be an offer, depending on the writer's intent. Also, placing an item up for auction is not an offer. It is merely a request for an offer. There are also problems with definiteness. For an offer to be guaranteed, the term of the offer must be definite. The UCC has provisions for supplying some missing contract terms. It establishes a price based on market value or valuation by a neutral party. An output contract obligates a seller to sell all of his output to one buyer who agrees to buy it. A requirements contract obligates a buyer to obtain all of his needed goods from the seller. Usually, delivery is at the seller's business. The time must be reasonable and payment is due upon receipt of goods. An implied warranty of merchantability means that the goods must be of at least average, passable quality in the trade. An implied warranty of fitness means the goods are suitable for a particular purpose. There is asymmetry in the rules for when an offeror's revocation of an offer is effective and when an offeree's acceptance of an offer is effective. The former is effective when the offeree receives it. The latter is effective when it is out of the offeree's control. These rules are not intuitive, require special emphasis, and provide excellent fodder for exam questions. Termination by revocation is effective when the offeree receives it. Common law rule means that the revocation of a firm offer is effective if the offeree receives it before he accepts. Option contract means that the offeror may not revoke an offer during the option period. Sale of goods is a writing signed by a merchant offering to hold an offer open which may not be revoked. When an offeree rejects an offer, the rejection immediately terminates the offer. This is termination by rejection. When an offer specifies a time limit for acceptance, that period is binding. When the ending date has passed, termination by expiration will occur. If the offer specified no time limit, however, the offeree has a reasonable period in which to accept. Termination by operation of law refers to when death or mental incapacity of the offerer terminates an offer. Destruction of subject matter terminates the offer also. For acceptance to be valid, the offeree must say or do something to accept. In a bilateral contract, the offeree generally must accept by making a promise. In a unilateral contract, the offeree must accept by performing. If the offer is ambiguous, the offeree may accept by either a promise or performance. The mirror image rule requires that acceptance be on precisely the same terms as the offer. Can a person form a binding agreement if he or she is intoxicated when making or accepting an offer? No. If one party is so intoxicated that he or she cannot understand the nature and consequences of the transaction, the contract is voidable. An offeree may include in the acceptance terms that are additional to or different from those in the offer. Additional terms are those that bring up new issues. If both parties are merchants, the additional terms will generally become part of the contract. Different terms are those that contradict terms in the offer. The majority of states hold that different or contradictory terms cancel each other out. If an offer demands acceptance in a particular medium or manner, the offeree must follow those requirements. If the offer does not specify a type of acceptance, the offeree may accept in any reasonable manner and medium. An acceptance is generally effective upon dispatch, meaning the moment it is out of the offeree's control. Under the doctrine of promissory estoppel, even if there is no contract, a promise may be enforceable if the offerer makes a promise knowing the offeree is likely to reply, or the offeree does in fact reply, and the only way to avoid injustice is to enforce the promise. One thing that invitations to bargain and price quotes have in common is that if they were offers, then the offerer would almost invariably be unable to perform if everyone who received the invitation or price quote could form a contract by accepting its terms. Suppose a homeowner sends a letter to friends and neighbors expressing interest in selling his home with an asking price of $200,000 and a closing on a date 3 months later. If two recipients respond by saying, "I accept," can the homeowner perform both agreements? Obviously not. He has only one house to sell. Is he therefore in breach of one of the agreements? If so, which one? If invitations to bargain and price quotes are understood in this fashion, then there should be no problem in recognizing why they are not offers. Letters of intent pose a different problem. A letter of intent is between two parties and does not raise the problem of multiple acceptances discussed earlier. The concern is that if negotiations break down, one party will treat the letter of intent as a binding agreement and seek its enforcement. Business people often want letters of intent near the start of negotiations because they serve valuable business purposes. Letters of intent can indicate areas of agreement and expose open terms, provide comfort that the distance between the parties' positions is small enough to warrant the time and expense of continued negotiation, interest investors to consider providing financing, and serve as the template for a definite contract if and when the parties reach agreement. Lawyers protect clients from the other side's undue reliance on the letter of intent as a binding agreement by peppering it with language disclaiming its creation of legal obligations and expressing its temporary nature, what is often called weasel language, because its purpose is to leave one's client with a way out of the deal. Evergreen Investments, a Montana company, was negotiating for 2 years to buy FCL Graphics, a commercial printing firm located in Illinois. The parties signed a letter of intent that included a purchase price of $53 million, payment terms, and the precise assets involved. The letter also stated that binding terms and conditions for a potential transaction will depend on a number of factors, including but not limited to the satisfactory completion of legal, business, and financial due diligence investigations and negotiation and execution of definitive legal documentation. Any proposed transaction will be subject to Evergreen's ability to arrange financing on terms satisfactory to Evergreen, sufficient to consummate the acquisition and provide adequate working capital to meet the company's ongoing liquidity requirements and other obligations. Consummation of the sale was also contingent on Evergreen obtaining satisfactory financing, the receipt of certain approvals, and Evergreen's completion of due diligence. 1 month after signing the LOI, FCL terminated negotiations. Evergreen sued for breach of contract. The trial court granted summary judgment for FCL, ruling that the letter of intent was not a binding agreement. Evergreen appealed. Do you think that the letter of intent is a binding agreement? In the courts, the judgment for FCL affirmed. Excerpts from the court's opinion are as follows. Whether such a letter reflects a binding agreement between the parties turns not on what the parties subjectively believed, but on what they expressly manifested in their writing. If no ambiguity exists in the writing, the party's intent must be derived by the court as a matter of law, solely from the writing itself. The clear language of the letter demonstrates that the parties did not intend the letter to constitute a binding agreement for the purchase and sale of FCL. The remainder of the letter clarifies that this was a proposed acquisition and a potential transaction that depended on and was subject to several factors and conditions, including, but not limited to, the satisfactory completion of legal, business, and financial due diligence investigations and negotiation and execution of definitive legal documentation, including non-competition agreements with all existing owners, as well as certain legal, regulatory, and other necessary third-party approvals. The court noted that the letter of intent contemplated preparation by counsel of a formal agreement and stated the parties would act in good faith to attempt to reach agreement on terms substantially similar to those in the letter of intent. The parties negotiated for 2 years and agreed to a letter of intent with the purchase price, payment terms, and assets to be sold. Why wasn't that enough to create a binding agreement? Well, the letter of intent left out many outstanding issues. For instance, Evergreen required additional time for satisfactory completion of legal, business, and financial due diligence. What does that mean? Due diligence is the process of investigating all the facts and circumstances surrounding a transaction and deciding whether to proceed. In an asset purchase such as this, the buyer would inspect the physical condition of all tangible assets, the title history of any real property, the presence of oil or hazardous materials in the ground, whether buildings had received all necessary zoning and regulatory approvals required for construction, 3 or more years of financial statements for any going business, and anything else that could affect the value of the assets being purchased and the risk of owning them. But why is this significant that Evergreen still needed to complete its due diligence? Because the letter of intent states that agreeing on binding terms and conditions for the sale depend on Evergreen's satisfactory completion of its due diligence. Does satisfactory completion mean that Evergreen could decide not to go forward if it wasn't satisfied with the results of the due diligence? Yes. Then why did they go to the trouble of writing and signing a letter of intent if it had no legal effect? Why bother? The letter of intent captured the state of their negotiations, showing where the parties agreed and where they did not. In complex negotiations like this one, which went on for 2 years, it's critical to the business people to keep track of the terms of the proposed deal. That's a major reason for creating the letter of intent. If the letter of intent is often important for business people, why do lawyers like to use them as well? Well, lawyers use them for the same reasons, to narrow down the field of open issues and keep track of all the deal points. In a complex deal such as this letter of intent, it can be quite lengthy. While lawyers recognize their value, they are also wary of creating a letter of intent that the other party can construe as a binding agreement. An offer is an act or statement that proposes definite terms and permits the other party to create a contract by accepting those terms. But sometimes we forget that by making a valid offer, we give that power to the other person. Sometimes corporate offers forget the point as well. Nationwide Mutual Insurance Company wanted to energize a regional meeting, so it announced a contest for the best company slogan to be used at the convention. They said, here's what you could win, his and her Mercedes, or an all-expense-paid trip around the world, additional prizes to be announced, and all prizes are subject to availability. David Mears and 184 other employees entered. Mears' slogan, at the top and still climbing, was the winner. One company officer told Mears that he had won the 2 cars, but another said that the cars were just a joke. Ultimately, Nationwide informed Mears that the prizes were never meant seriously. The company did, however, use his slogan for the convention. The banners, booklets, and balloons all echoed with this phrase. Mears failed to see the joke and filed suit in federal court. The jury didn't laugh either. They awarded Mears $60,000, the value of 2 of the least expensive Mercedes. The trial judge gave a judgment, NOV, for Nationwide, ruling that the terms of the agreement were too vague to enforce. On appeal, however, The Eighth Circuit Court of Appeals agreed with the jury and reinstated the $60,000 damage award. The contract was unilateral. One knows this because Mears accepted the offer by tendering performance, not by making a promise in response to Nationwide's offer. Nationwide did not intend their offer to be taken seriously. They apparently wanted employees to suggest slogans, but considered the prizes to be a joke. If Nationwide didn't intend to be taken seriously, then why did the jury find that Mears accepted it and created a contract? Well, there's a difference between subjective intent and objective intent. Subjective intent is what people believe or feel in themselves. Objective intent is what a reasonable, neutral third party believes to be a person's intent based on their words and conduct when making the offer. The terms of the offer was fairly vague, and the trial court thought so it entered a judgment of NOV, non obstante verdicto, after the jury decided in favor of Mears. A judgment NOV is a procedure that allows a judge to overrule a jury's verdict if the judge does not believe the evidence supports it. When the case was appealed, the court reversed the judgment NOV and reinstated the jury's verdict, awarding $60,000 to Mears. So, what lessons should we draw from this example? Be careful proposing anything that a court might construe as an offer. Vagueness or ambiguity in an offer or acceptance guarantees problems and may lead to litigation. The executive or consumer who articulates to herself precisely what she wants and then bargains clearly for it is likely to spend more time doing business and less time in court. Congratulations, you made it through Chapter 11 on agreement.